I don't know how to say it. That's good morning or good evening, because here it's the morning. So, dear host, delegates, and all participants, first I would like to thank the Human Rights Council of the United Nations for offering such an invaluable opportunity to discuss and exchange important issues on the legal protection of human rights. I'm deeply honored to be here and share my views and insights with experts and scholars coming from around the world. My years of study on China's legal history allows me to observe and parse China's achievements and shortcomings in legal protection of human rights since China reopened to the West in 1978. Today, I'm going to share with you some of my recent findings and arguments in regard to China's efforts and accomplishments in constructing and improving its human rights legal system since 1978. At the same time, I also hope that today's scholarly discourse and exchange of views will enhance our understanding of the human rights practices in different countries and promote international cooperation and dialogue in the field of human rights. Since China launched its reform and opening policy in 1978, the world's former most populous country has experienced tectonic changes. These changes are not only visible in China's rapid economic growth and social development, but also have a profound impact on the construction and the improvement of the legal protection of human rights. The modern judicial reform that began in 1978 is the third most important judicial reform in the 20th century. The other two legal reforms are the judicial reform in the late Qing dynasty and the judicial reform in 1952 and 1953. The primary goal of the first judicial reform in the late Qing dynasty through the Republic of China was to seek Western powers' repeal of the humiliating extraterritoriality by comprehensively introducing the Western legal systems such as civil law, criminal law, administrative law, and modern prisons. It also adopted the notions and the practice of modern Western judicial independence and professional judges and lawyers. The late Qing judicial reform also abolished the corporal punishment and the torture that had existed for thousands of years in China. Contrary to the judicial reform in the late Qing dynasty and the Republican period, the judicial reform in 1952 abandoned all Western laws and the judicial systems and replaced them with a socialist judicial system, resulting in a lack of judicial independence, arbitrary judgments and punishment, and the return of torture. Especially during the Cultural Revolution, the China's judicial system suffered serious damage. In the wake of the tragic and arguably lawless Cultural Revolution, many Chinese leaders who had been attacked during the Cultural Revolution, such as Deng Xiaoping and Peng Zhen, determined to launch the third judicial reform after 1978, which restores professional judges and lawyers, abolishes torture, and promulgates hundreds of important new laws, including civil law, criminal law, judge law, administrative law, as well as important laws such as civil procedure law and criminal procedure law. By 2003, the National People's Congress alone had enacted 430 laws and regulations. The State Council and the Local People's Congress had passed 900 and 9,000 laws and regulations respectively. In addition, about 69% of laws passed by the National People's Congress have been amended at least once, and 19% of laws have been amended at least twice. After the reform kicking off, China's professional judges and lawyers have grown rapidly and play an important role in protecting human rights. For example, in 1979, there were only 58,000 judges in the country, but by 1997, the number had ballooned to 250,000. The lawyer system, which virtually disappeared after 1957, had only a small number of licensed lawyers in 1979. But by 1992, the number of lawyers reached 50,000. In the early 21st century, there were more than 200,000 practicing lawyers in China. In 1989, the National People's Congress enacted the Administrative Procedure Law, which created a legal basis to protect the people's legal rights against official infringements. More important, the 1982 Constitution restored many citizens' rights and obligations stipulated in the 1954 Constitution. In 1997, President Jiang Zemin pronounced for the first time that China would construct the rule of law. In the 1999 constitutional amendment, constructing the rule of law was formally written into the Constitution. This is not only in line with the prerequisite for China to join the WTO and building a market economy, but also shows that the Chinese government has reconsidered judicial independence and legal rights and the interests of citizens. After Sun Zhigang died in forced detention in 2003 without a temporary residence permit, the National People's Congress speedily abolished the detention and reparation system to protect citizens' legal rights from the abuse of law enforcement. From 1980 to 2010, China's major newspapers, such as the China Youth Daily and the Legal Daily, had published numerous law-related articles to help improve citizens' legal consciousness. On the one hand, the reports improved the citizens' consciousness in safeguarding their legal rights. On the other, by exposing and criticizing the illegal activities of law enforcement agencies and governments, the reports could surveil and prevent public power from violating citizens' human rights. There is no doubt that the latest judicial reform after 1978 has not been thoroughly implemented, and many older legal problems remain, including law violations perpetrated by the government and law enforcement agencies, arbitrary rulings by judges, and defects in administrative litigations, which have neutralized the legal rights and the interests of many citizens. A few years ago, in one case occurring in Guizhou, where local officials abused their power and arbitrarily arrested a female entrepreneur. This female entrepreneur has completed many construction projects for the Liupanshui municipal government in Guizhou since 2016, and the municipal government owed her 220 million yuan. She had repeatedly asked the government for paying the debt, but the local police arrested her in late 2023 on charges of picking quarrels and provoking troubles. This case shows that China's legal protection of human rights remains unsatisfactory, especially in some remote provinces and cities. Furthermore, we should note that the legal protection of human rights has different standards and requirements across the world. In the George Floyd case that played out in Minnesota in 2021, we can see that even in the United States, where human rights protection is relatively more matured and complete, police abuse of power still exists. By deepening its judicial reform, China will only engage in more exchanges and cooperation with countries that have better legal protection of human rights, but also continue to improve its legal protection of civil rights. In addition, through academic exchanges, legal research, and human rights dialogue, China and Western countries like the United States can enhance their mutual understanding and collaborate in seeking the best practices of protecting human rights. International human rights standards and commonly concerned global human rights issues such as immigration law or immigration rights and environmental protection also provide a platform for cooperation between the two countries. With more comparisons and exchanges, China and the United States will be able to deepen their mutual understanding on human rights protection. Finally, I would like to take this opportunity to appreciate the organizers and all participants once again. Through our joint efforts and exchanges, we will not only enhance our understanding of the process in the legal protection of human rights, but also pave the way for our future cooperation and improvement. 45 years after China's reform and open policy, China has made progress in legal protection of human rights. In the meantime, today's dialogue among scholars from different countries helps us see the differences in concepts and practices among different parties. These differences both pose challenges and offer opportunities for our common progress. So long as China and the United States continue their dialogue and cooperation and learn from each other with an open and inclusive mind, both countries can help promote the legal protection of human rights around the world. Thanks again to everyone for listening and participating. I look forward to continuing this innovative and encouraging conversation with you in the future. Thank you.